Item 5 carries. Item number 6 is to receive and place on file annual salary increase for Corrections Officer Levi Prime from $16.39 to $16.98 per hour, effective May 2nd, 2019, upon the recommendation of Steve Ellifritz, Jail Administrator, and in accordance with the labor agreement.
I'll make the motion to move item 6.
I'll second.
Motion and a second. Any questions or comments? Hearing none, all in favor?
Aye.
Opposed? Item 6 carries. Item number 7 is to accept and place on file the status change from part-time to full-time for Anthony Belletti, Corrections Officer, effective July 1st, 2019, per recommendation of Steve Ellifritz, Jail Administrator.
Mr. Chairman, I'll move item 7.
Second.
We have a motion and a second on item number 7. All in favor? Opposed? Item 7 carries. Item number 8 is to accept and place on file the status change from part-time to full-time for Aaron Marcelin, Corrections Officer, effective July 1st, 2019, per recommendation of Steve Ellifritz, Jail Administrator.
Mr. Chairman, I motion we move item 8.
I second.
Motion and a second. Questions or comments on item number 8? All in favor?
Aye.
Opposed? Item 8 carries. Item number 9 is to accept and place on file the status change from part-time to full-time for Camden Kramer, Corrections Officer, effective July 15, 2019, per the recommendation of Steve Ellifritz, Jail Administrator.
Mr. Chairman, I'll move item 9.
I'll second it.
Motion and a second on item number 9. Is there any questions or comments? Hearing none, all in favor? Opposed? Item 9 carries. Item number 10 is to accept and authorize the status change for Heather Perry from Sergeant, Corrections Officer, full-time night to Corrections Officer, full-time, effective July 1st, 2019, per the recommendation of Steve Ellifritz, Jail Administrator.
Make the motion to act on item 10.
I'll second.
We have a motion and a second. Any questions or comments?
Yeah, we had like 4 or 5 of these from jail. Is there something special about that, or?
Well, no, we had a couple that resigned, one went down to boot and stuff, so the part-time people moved to full-time. Heather, on the last one, she was the night sergeant, with the understanding when she became sergeant, she was gonna go to nights to run that shift. Now she doesn't need to do that anymore. She wants to come back to days, so she has to give up to sergeant.
Thank you.
Thank you.
Any others? All in favor?
Aye.
Aye.
Opposed? Item 10 carries. Item number 11 is to approve taxes of Marion D. Halterman, 305 West Front Street, Clare, Iowa, be suspended under the provision of Iowa Code Section 427-9.
Mr. Chairman, I'll move item 11.
Second.
Motion and a second. Questions or comments? And this is a suspension. They still do accrue. They're just put on hold from payment. Roll call vote.
Declaw, aye.
Crossman.
Campbell, aye.
Conrad, aye.
Vote aye.
Item 11 passes. Item number 12 is to adopt resolution number 2019-25, a resolution for a 28B agreement with Webster County and the incorporated cities of Webster County.
Mr. Chairman, I motion we move item 12.
I'll second.
We have a motion and a second. Questions or comments on item number 12?
So the update stems from the state of Iowa requesting that the Telecommunications Board creates an executive committee within the Telecommunications Board that will handle confidential information regarding law enforcement.
Thank you. Hearing no questions, all in favor? Oh, roll call vote.
Declaw, aye.
Carlson, aye.
Campbell, aye.
Conrad, aye.
Vote aye.
Item 12 passes. Item number 13 is to receive and place on file the Webster County Weed Commissioner Noxious Weed Policy.
Mr. Chairman, I'll move item 13.
I'll second it.
Motion and a second. Questions or comments on item number 13? Hearing none, all in favor?
Aye.
Opposed? Item 13 carries. Item number 14 is to approve the services agreement with Shuck Brinston Incorporated for the clock tower renovation project at an estimated cost of $432,800 and allow the chairman to sign.
I'll make a motion to act on item 14.
I'll second.
We have a motion and a second. Questions or comments on item number 14?
So, talk about the timeline.
Well, the services agreement is for the work plan and design fee estimates for the clock tower renovation project. We are planning on having a couple public information meetings, hopefully in July and August. We'll have more information then.
Questions or comments on item number 14? All in favor?
Aye.
Opposed? Item 14 carries. Item number 15 is to approve and authorize the chair to sign fiscal year 2020 roadway maintenance agreement with Iowa Department of Transportation for roads within Brushy Creek State Park.
Mr. Chairman, I'll move item 15.
Second.
Motion and a second on item number 15. Any questions or comments?
You want to explain that?
Yeah. Jamie Joel, county engineer. We've had the same agreement with the DNR for a number of years, and it's just for the main road through there. We plow the snow, and occasionally on some of the side roads, if they have maintenance issues that they aren't equipped to handle, then we'll do it for them, and we send them a bill, and they reimburse us for all our costs.
This said the Iowa Department of Transportation, not the DNR.
No, I should say the DNR. Well, I guess the road, it's a DNR facility, but the road is through under the control of the DOT.
Oh, okay.
So they handle all the state roads, so it's a state park.
But the main roads are to go through there.
Well, that's
Another
great,
question.
great.
I just questioned it.
It is our road.
DNR, DOT.
Within the park, they plow the snow normally, that they're reimbursing us for doing it.
I was just curious why it was the Department of Transportation, not the DNR.
There's some language in there about the DNR for like the special maintenance part.
Any other questions on item number 15? Hearing none, all in favor?
Aye.
Opposed? Item 15 carries. Thank you.
Yep.
It is now the citizens' opportunity to address the board with items not on the agenda.
Morning.
Good morning.
Excuse me.
Thank you. My name is Keith Puntany. Some of you may associate me with the Dakota Access lawsuit that just went through the Iowa Supreme Court. I'm a landowner in Webster County, both in Dayton Township and Lost Grove Township. And the purpose that I'm here is to request the opportunity to come back before the board and talk to you about the next step in the Dakota Access Pipeline, which is the county compensation hearing stuff that's going to happen in whatever next time period you folks get involved with as well. As you know, ISG was hired by 13 of the 17 counties to do the oversight under the AIMP, the Agricultural Impact Mitigation Plan, on the restoration of the Dakota Access pipeline with landowners. They're still in the process, as I understand it, of compiling information about all of the issues that still remain to be, fixed in the counties. their last communication with the Iowa Utility Board was that they're gonna do it across the whole 346-mile route, not on a county-by-county basis, which is why they've not turned over the individual information to the counties about the stuff in each of the counties. So that's still ongoing. And several of the counties have reported to me that, and I'm assuming this is true with you guys, that they're still under contract with you and being paid by you guys at this time as well, okay, in terms of that. The controversy on the compensation hearing stuff came about because the Iowa Code Chapter 479B subsection 30 directs that the county compensation hearings all come through you, the supervisors, okay, in terms of that. And so based on whenever each of the counties certifies that the construction period has ended, and then that's not necessarily the same certification as done by Dakota Access, which is set May 15th of 2017. Whenever you certify in your county, probably in conjunction with ISG or some other determination, that it is done, you trigger what's called a 90-day minimum period by which landowners then have to negotiate with Dakota Access on trying to arrange the proper payments for the so-called construction expenses, okay, the remediation expenses that are necessary. At this time, I know of 5 counties, 2 in northwest Iowa, 1 in southeast Iowa, that have gone ahead and set, dates. Polk County and Story County have not. My understanding is Boone County will not set a date, and I've come to ask you to not set a date as well, because there were a lot of things in that code section 479B30 that are just totally unclear, number one. Secondly, once you set a date, that's a minimum date, not a maximum date. That means that you don't have just 90 days, it can be more than 90 days, but you can't trigger the request of the county supervisors to appoint a county compensation hearing, before that 90-day period runs. But the concern is that we have 18 different counties, 17 of which have major route, type of issues. And we have, I think, somewhere between 3 and 5 different district court, judges, chief judges that are going to be involved in this. And obviously, this is going to end up a legal matter, because the way it works is if you appoint a county compensation hearing and we go through the process like the eminent domain hearings where there's an appeal. And that appeal can either be by Dakota Access or the landowners, going forward. And so it's fairly important that the quote construction damages area be defined in large detail, so that all of the counties deal with them the same, and not only all the counties, but the folks that are appointed for the actual hearings have some kind of guidelines. And so I'd like to come back to you and spend a half hour, 40 minutes, or an hour or so outlining some of the issues, and I'd like to use my own land and some of the issues that have come up as an example and show you what the issues are. In a nutshell, we have the statute itself is not very clear on a number of things that are pretty important. One of them is notice, okay? So there's nothing in the statute that prevents you from just passing the resolution and publishing it in the newspaper, and that's like your board meetings, that's notice. But we have 60% of the landowners in Iowa that are renting land in one form, and a large number of them are out of state, and a large number of them are seniors, and a lot of them can't afford to go out and hire counsel to try and figure out what construction damages are and all of this other stuff. So the notice provision is one side of that argument or that issue that's out there. The other is just what do construction damages consist of, okay? Is construction damage defined by the right-of-way, the temporary or the permanent right-of-way? Is it defined by the time period? When you declare the end of the construction, period, Well, what about damages that occurred outside of the right-of-way, such as dewatering or driving over, property and other kind, are those due to construction, or are they not? So we think there's a number of issues that need to be raised. You folks are the ones that have to raise those issues. We think those will be answered by the chief justices of each of the district, courts, in terms of that, and we think there needs to be some uniformity, okay, in terms of those kinds of issues. So that's the discussion I would like to have with you, at some future date. Obviously, the other side of that argument is the AIMP, that's Agricultural Impact Mitigation Plan. And that's what you were responsible for theoretically, because the IUB said the counties are responsible for enforcement of the AIMP. Well, you delegated that to ISG. ISG has said they're only a recording instrument, they have no power. That was your power to follow the AIMP. And a large number of us have actually hired a PhD soil scientist and others to come out and document the damages, okay? So like it or not, we're in the circular firing squad where you guys are going to get involved, in terms of the case, both at the county compensation side and also potentially if it were to go forward, okay? In terms of all of that. Something we need to at least discuss, okay? This is not aimed at you, any of this stuff, but this is just one of those types of things. And the last thing that I want to say is this is extremely important to me personally as a landlord at Dick Swanson, landowner at Dick Swanson, and a bunch of your folks here in the county. I can document tens of thousands of dollars of damage in my land. Okay, so how you structure the county compensation hearings will affect me dramatically under B30. There's also another code section out there which is B29, and B29 basically says, well, if it's not a B30 damage, construction damage, it's a B29 damage, but the difference is there's no ability for me to have a county compensation committee appointed under B29. That means I negotiate directly with Dakota Access and have to go to court, straight to district court with what we would consider an arbitration-like proceeding, which is what the county compensation hearings are. The other difference is under B30, if in my negotiations with Dakota Access, my damages exceed 10% of their final offer, they have to pay my attorney's fees, my expert costs, everything associated with the county compensation hearing. So it's extremely important to me as a landowner, to be able to bring all of this forward at that county compensation, hearing and deal with it at that point.
The difference between B30, I know, is direct construction damages, B29 is environmental, or what is that?
No, it's other damage, things discovered after.
Okay.
And that's the other question, is what's discovered afterward. For instance, we know in the case of titling, we had to wait 3 years. Okay. Well, if Dakota Access says the construction period ended in May 15th of 17, and we're having to wait 3 years to put, is that in or out? Okay. That's another reason why we would like you to wait in terms of defining construction period. Okay, because there are a lot of things that are due to the nominally to the construction of the pipe. Okay, and the question is, are they in or are they out in B30? And I think you are in control of that determination by the date you set and then by the definitions that you give for construction damages. Okay. Does that answer your question?
Yep.
Okay. Does anybody else have questions?
I guess I have a question for Mr. Campbell. This is your district. Have you fielded a lot of complaints about Dakota Access and that people come to you with this situation?
Through the project, ISG Dakota Access was very good to work with. We have had some questions and concerns since the project has not finished, but their construction work has been done. We've had some tiling issues, but overall they have been good to work with, so we hope that this will be a good process too.
Yeah, and I would also like to point out that, just for your own knowledge, this affects the wind turbine fields as well. I know that Dan Rasmussen's been working on the 110 wind turbines north of my property for 5 years, and he's now working on the 192 south of that over by Boxholm. Same kinds of issues, in both types of, whether it's a pipe or a wind turbine or whatever, the same issues are there. I have one document I'd like to pass out to you, with your permission.
Sure.
Sure, okay. Okay. And we'll talk about this in greater length if you allow me to come back and talk to you. The Enbridge pipeline, which is a Canadian tar sands pipeline, basically put in a line back in 2008 and 2009, and it came out of Canada and it went through Minnesota and went over to Wisconsin and down into Illinois, okay, in terms of that. So in 2010, that pipeline was in service, okay, in terms of that. They're actually now redoing another line up there in the same area. But 5 years later, in 2015, the Illinois Farm Bureau in LaSalle County actually did a survey of all of farmers who were affected by that pipeline. I'd like to give you a copy of that survey, because what that survey shows is right on point with what we as landowners are finding with the Dakota Access Pipeline. It's also right on point with two cases out there. One's the Timotson case, which is an Iowa Supreme Court case in 2016 with Roger Timotson alleging crop damages and compaction and all kinds of soil issues that are there. And there's now a federal class action suit over the same issues from the Minnesota landowners that are there. And I'm sorry, that's all I got with me.
Sure.
Yeah.
So your timelines and your communications, would you make sure that you're directing that through our county attorney's office so that he can get everything scheduled?
Yeah, I will make myself available when, if we could do it in the next, probably 10 to 14 days, if we could set something like that up.
Sure, so naturally, I'm aware of this just now as you're bringing it up to the board, but as I read 479B30, several questions come to my mind. You mentioned that the clarification for the notices and the damages would come from the chief judge of the district, but it appears to me that that would not occur until the petition was actually on file. Is that your understanding as well?
No, that's not what John Murray, who's an attorney up in Storm Lake, and I have talked a lot about this. We think you have the right, if you have questions under the law, to go to the chief judge and say, okay, as we read the statute, here's what our questions are, and ask for them to render some kind of an initial opinion, okay, in terms of what the statute actually means. And we think that would also afford the opportunity for the chief justices of all of these district courts to talk about this, since there are similar, concerns. It's a 346-mile pipeline, and there's 910 farm families and 1,257 parcels of land that are affected by all of this. And it's not just the eminent domain; it's anybody who has the pipeline going through the land, whether it's voluntary or eminent domain or however the pipe is going through. If they have now discovered issues, and as we all know, the huge rains we've had have now awoken a lot of people, tenants and owners, to issues relative to the pipeline that are there. And so that's why we're concerned that the proper notice and the proper definitions, and everything else be determined across the entire pipeline. And I think you as a county attorney have the ability to join with your other county attorneys. And I think Boone and Story and Polk would do that for sure with you, okay, in terms of raising similar, first talking among yourselves and then raising similar questions that could go to the chief judge, and beyond.
All right.
So that's the proposal. I'm an attorney, so I'll be glad to work with you as well.
I'll give you my information.
Okay.
So was this survey sent to everybody or just the people that used eminent domain?
It was not eminent domain. It was people who had the pipeline coming through there. Okay. It was not.
It was taken from filing for eminent domain powers.
Yeah, some of it was, yes.
Well,
Yeah.
some of it.
Yeah.
So, I don't understand. Was it everybody, the 61,
If that says eminent domain, then that's your guy. That's your guy.
just the people that went through eminent domain got this?
And again, this was a survey that was just done to check what the Farm Bureau's members thought about the pipeline. The eminent domains are the ones that are easy to find notice-wise. I don't think, it did not go out across everybody on the pipeline, if that's what you're asking. No, it was sent out.
guess I have a problem with that.
Okay.
If you do a survey, you survey everybody to get the cross-section of what, not just the people that have problems with the property start. The people that
Well, it's not about whether or not it was eminent domain, those were just the people that they could easily reach out and identify, and they wanted to get some information, so, yeah.
But they all use it.
That's fine. And yeah,
Not just.
yeah, no, it is just a survey, that is all it is, okay? And I will tell you that it is supported by, other non-eminent domain folks, whether you look at the Alliance Pipeline, federal case that's out there, or the Tennyson case, where all of these were voluntary easements in those. The same things pop up all across the board. I'm just raising the issue with you, those are the concerns.
Okay.
Thank you.
Anything else?
And if you wanted to get in touch with me,
I'll give you my information.
okay.
Thank you very much.
Thank you.
Thank you, sir.
Any other questions or comments? All right. Again, thank you very much, sir. Board of Supervisor Committee reports.
Mine started this week, so awesome.
Conservation tonight, 5:30, Kennedy Park.
Got a lunch and learn today?
Yes.
Linking Families on Thursday.
All right. Our next item on the agenda is item number 16, closed session per Iowa Code Section 21.5J to discuss purchase of real estate. Do I have a motion?
So,
Seconded.
Motion and a second. All in favor to go to closed session?
Aye.
Opposed?